Hello everyone, today we'll study about fundamental rights. If you have not yet subscribed to my channel, please subscribe, like, share and comment. Okay, let us start. First we'll see what are rights. So the rights are entitlement to perform or not to perform certain actions in certain states. We'll see the categorization of rights. First one, natural rights. Becomes available to individuals by virtue of their birth as a human beings. For example, right to life and liberty is example for natural right. Next we'll see human rights. The rights which are considered as fundamental to human dignity and a well-being are called as human rights. For example, right to freedom of religion and right to fair trial. Right to fair trial. Next we'll see legal rights. The rights which are conferred by the statutes enacted by the legislature. The rights which are conferred by the statutes and which are enacted by the legislature. For example, right to strike and a patent right are example for the legal rights. Next we'll see constitutional rights. The rights enshrined in constitution, including the fundamental rights and other constitutional rights, are called as constitutional rights. Next we'll see civil and political rights. The political rights are concerned with the structure of the government and institutions of the public power. For example, right to vote is a political right it is. Next, civil rights. Civil rights are connected to the real citizenship and a participation in the political process. For example, right to freedom is an example for the civil right. Next, we'll see fundamental rights. Fundamental rights are called as because of the two reasons. First one, they are mentioned in the constitution which are guarantee them, and other reason, justiciable. They are justiciable or enforced through the courts. First one, the fundamental rights, constitution which are guarantees. First thing, they are mentioned in the constitution which are guarantee them, and second is justiciable, that is these can be enforceable through the courts. Fundamental rights can be enforceable through the courts. And next, they are enshrined in the part 3, article 12 to 35. The fundamental rights are influenced by the freedom struggle and the constitution of the USA, that is the Bills of Rights. We'll see 6 fundamental rights. See, originally the constitution provided for the 7 types of fundamental rights. Now only we have 6 fundamental rights. The right to property was deleted from the list of fundamental rights by the 44th Constitution Amendment. Right to property is deleted through the 44th Constitutional Amendment 1978. Later it is made as a legal right under the Article 300A in Part 12. Okay, we'll see what are the 6 fundamental rights. First one, right to equality, the Article 14 to 18, and Article 19 to 22 is right to freedom, and Article 20 to 23 to 24, right against the exploitation, and Article 25 to 28, right to freedom of religion. Next, Article 29 to 30, cultural and educational right, and Article 32 is a right to constitutional remedies. These are the 6 fundamental rights. The property right is deleted from the fundamental right. Next, we'll see features of the fundamental rights. Some fundamental rights are available only to the citizens, such as Articles 15, 16, 19 and 29 and 30 are available to only citizens, and while other rights are available to all persons, whether citizens or foreigners or legal entities. Next feature, available against. Most of them are available against the arbitrary action of the state. Most of them are available to the against the arbitrary action of the state, exception for the article 79-15 of subclause 2. See, when the rights are that are available against the state action, only that are violated by the private individuals. There are no constitutional remedies, but only ordinary legal remedies. No constitutional remedies, but only ordinary legal remedies. Some of the fundamental rights places limitations on the authority of the state, that is negative in character, such as Article 14, Article 15 subclause 1 and Article 16 subclause 2, etc. And some confer the certain privileges on the persons, that is positive in nature, such as Article some negative in characters are the 14, 15 and Article 16. We'll see what positive in character, which articles are positive in character. That is Article 25, 29 of subclause 1 and 30 of 1. These are all positive in nature. Next, fundamental rights are justiciable. See, the aggrieved person can directly go to the Supreme Court in case of violation of their fundamental rights. That is justiciable. Next, they are defended and guaranteed by the Supreme Court. And next, the Parliament can curtail or repeal them by a constitutional amendment act, but without affecting the basic structure of the Constitution. See, the Parliament can amend the fundamental rights, which can curtail or repeal them by constitutional amendment, but without affecting the basic structure they can do. Next feature, they are not absolute, but instead subject to reasonable restriction by the state. The scope of these rights is also limited by Articles 31A, 31B, 31C, 33, 34 and 35. They are not absolute, but instead subject to reasonable restriction by the state. They have limitations. Next, we'll see suspended. See, the fundamental rights can be suspended during the national emergency, except the rights guaranteed by the Article 20 and 21. Except 20 and 21, other rights can be suspended during the national emergency. And Article 19 can be suspended only emergency on the grounds of war or external aggression, and not on the ground of armed rebellion. See, the Article 19 cannot be suspended during the armed rebellion. They can be suspended only on the grounds of war, external aggression. Okay. Next, we'll see amendability of the constitutional rights. Fundamental rights. Amendability of the fundamental rights. First one, Sankari Prasad case, 1951. In Sankari Prasad case 1951, the judgment was Parliament has the power to amend the fundamental rights. In this judgment was can amend the constitution, can amend the fundamental rights. And next, in Golaknath case 1967, the judgment was the fundamental rights given a transcendental position in constitution cannot be amended. So the judgment was fundamental rights cannot amend. Next, in Keshwanand Bharati case 1963, it said that the doctrine of the basic structure of the constitution, fundamental rights are the basic structure of the constitution. of the basic structure of the constitution. Next, in Mineral Mills case, Supreme Court invalidated the Article 368. Supreme Court invalidated the Article 368 subclause 4 and 368 subclause 5 as they curtail the judicial review. So invalidated. Next, in IR Coelho case, the laws placed in the ninth schedule. The laws were placed in the ninth schedule from the date of the Keshavanand Bharati verdict, subject to judicial review. In Shankari Prasad case, it gives the judgment Parliament has the power to amend the fundamental rights. That is, Parliament can amend the fundamental rights. In Golaknath case, Parliament cannot amend the constitution, the fundamental rights. And in Keshavanand Bharati case, fundamental rights are the basic structure of the constitution, said in judgment. And in Mineral Mill case, in the judgment, Supreme Court invalidate the Article 368 and 368 subclause 5. And in IR Coelho case, laws placed in the ninth schedule from the date of Keshavanand Bharati case, verdict subject to judicial review. Subject to judicial review. Okay, next we'll see fundamental rights. What are the fundamental rights? First one, right to equality, which is from Article 14 to 18 are right to equality. First one, equality before law and equal protection of the law. Article 14 says equality before law and equal protection of the law. See, equality before law is inspired from the British tradition. Equality before law, this is British UK. It is inspired from the British tradition and it is negative in orientation. That is, the state is restricted from making any discrimination between two citizens. On the other hand, equal protection law. It is borrowed from the American Constitution, USA, and it is positive concept. The equality, that is the equality of treatment under equal circumstance, all protective discrimination. See, equality before law is inspired from UK and it is negative in orientation. That is, the state is restricted from making discrimination between two citizens. And the equal protection of law is inspired from the USA Constitution and it is positive concept. That is the equality of treatment under equal circumstance, all protective discrimination. See, the rule of law, the absence of arbitrary power and equality before law as embodied in Article 14 is it is a basic structure of the Constitution. Rule of law, that is Article 14, is the basic structure of the Constitution. In the case of Indira Sawhney case 1992, Indira Sawhney case in 1992, rule of law mentioned as a part of the basic structure. Rule of law was mentioned as a basic structure. It was a part of the basic structure. Next we'll see Article 15, prohibition of the discrimination on grounds of religion, race, caste, sex or a place of birth. It states that prohibits the state from discriminating against any citizen on grounds only on religion, race, caste, sex, place or a birth or any of them. And it says that it prevents the private citizen from discriminating against the other citizen on same grounds. The exceptions, the state can make special provision for women and children. In that case, you cannot say it prohibited. It is accepted that state can do special provision for women and children. And SC/ST and added Article 15 of 4 by Constitutional First Amendment 1951. And state can also do the special provision for social and economically backward classes and economically weaker sections. You'll see this Article 15 is exception for women, exception for women and children, SCSTs, and socially and educationally backward classes, and economically weaker sections, EWS. It is these are except Article 15 give the exception for this. Next we'll see Article 16 says that equality of opportunity in the matters of public employment. Equality opportunity in the matters of public employment. It says that it prohibits the discrimination against citizen in respect of employment under the state on grounds only of the religion, race, caste, sex, descent, place of birth, residence of any of them. There should be equality of opportunity in public employment. Again, there are some exceptions. The state can prescribe the residence as a condition for certain employment or appointment in state or union territories, and provide for reservation of appointments of or a post in favor of any backward classes or economically weaker sections. Here we have exceptions again. We have exceptions of backward classes and economically weaker sections. State can give a certain reservation for them. Next we'll see Article 17, abolition of untouchability and a prohibition of its practice. Abolition of untouchability and empowers the parliament to make it a punishable offence. See, the parliament made two enabling acts for enforce this provision. What are those two? Protection of Civil Rights Act 1955 and Scheduled Castes and Tribes 1989. Next, Article 18, abolition of titles except the military and academic. See, it prohibits the state from conferring any title or other than military or academic distinction. And it places the limitations upon any citizen or a non-citizen who holds any office or a profit under the state in respect of accepting any title, present or emolument from foreign state without the consent of the president. See, you cannot hold any emoluments or present from foreign state without the consent of the president. Next we'll see right to freedom, Article 19 to 22. In that, Article 19 says that the protection of 6 rights. First, speech and expression, assembly, association, movement, residence, profession. These are the 6 protection rights. It guarantees to all the citizens. The state can impose reasonable restriction on the enjoyment of these 6 rights only on grounds mentioned in the Article 19 itself and not on any other grounds. That's during the emergency of the declared on the grounds of war or external aggression. Article 19 can be suspended only when the emergency is declared on the grounds of war or external aggression and not on the ground of armed rebellion. See this first one, speech and expression. The freedom of speech and expression includes the freedom of press, propagates one views, and right against trapping, telephonic conversion, and right against band, right to demonstration but not strike, and freedom of silence. The right to strike is a statutory right and it's not a constitutional right. And we have a reasonable restrictions over this freedom of speech and expression. when it comes to the matter of sovereignty and integrity of India, security of the state, friendly relations with the foreign state, public order, decency or morality, contempt of court, defamation and incitement to any an offense. These are the grounds, reasonable restrictions we have on freedom of speech and expression. Freedom of speech and expression. Next we'll see assembly. Assembly assemble peacefully and without arms. That is includes the right to hold public meetings or demonstration and exercised only on public land. Again we have a restriction on this sovereignty and integrity of India and public order. If it is affecting the sovereignty and integrity of our India, then you cannot assemble. Next, association. Form the association or unions or cooperative societies. The right to form political parties, companies, organization, and even right to not join any organization. You have right to form or not right to join any organization. You have a freedom on this. Note your right to obtain recognition of an association is not a fundamental right. Right to obtain recognition of an association, it is not a fundamental right. Next, movement. Move freely throughout the territory of India. Right to move out of the country comes under Article 21, not in this. It is move freely throughout the territory of India, only in territory of India. Right to move out of the country, it comes under the Article 21. Next we'll see residents. Reside and settle in any part of the territory of India. You can reside or settle in any territory of part of the India, only in territory of India. And profession. Practice any profession or to carry on any occupation or a trade or a business. You can practice any profession or to carry on any occupation or trade or business. Next comes Article 20, protection of in respect of conviction for offense. Protection in respect of conviction for offense. It grants the protection against the arbitrary and excessive punishment to an accused person. It provides that there be a no ex post facto law and no double jeopardy and no self-incrimination. It grants the protection against arbitrary and excessive punishment to an accused person. It provides there no ex post facto law. Means the limitation on enactment to an ex post facto law is imposed only on criminal laws, not on civil laws or tax laws. Okay, it imposed on only criminal laws, not on civil laws or tax laws. Next one, no double jeopardy. No double jeopardy. In this, departmental inquiries are not, however, not treated as a violation of this principle. Double jeopardy means the person cannot be prosecuted and punished for the same offense more than once. You cannot punish more than once for the same offense. That is no double jeopardy. And the next one is no self-incrimination. No self-incrimination. In this, no person accused of any offense shall be compelled to be a witness against him. Means person cannot witness against himself. Cannot himself against, cannot give witness against himself. No self-incrimination means cannot witness against himself. Next we'll see Article 21, protection of life and personal liberty. This Article 21 says that no person shall be deprived of his life or a personal liberty except according to the procedure established by the law. No person shall be deprived of his life or a personal liberty except according to the procedure established by law. Next we'll see Article 21A, right to elementary education. It mandates the state to provide free and compulsory education to all children of the age 6 to 14 years. It mandates the state to provide free and compulsory education to all children of the age of 6 to 14 years. It is added by the 86th Constitutional Amendment Act of 2022. This right to elementary education is added through the 86th Constitutional Amendment Act of 2002. And it pursuits of the Article 21A, the Parliament enacted the right to children to free and compulsory education, RT Act 2009. The Parliament also made the right of education RT Act 2009 for the children to free and compulsory education. See, this Article 21A, right to elementary education was not there in the original constitution. It is added through the 76th Constitutional Amendment Act of 2002. Okay, next we'll see Article 22, protection against arrest and the detention in certain cases. We'll see the first part, protection against the arrest. The cases of ordinary law, the rights conferred the right to be informed of the grounds of arrest. The arrested person should inform on what grounds he is arrested, and right to consult and be defended by a legal practitioner. He can have a legal practitioner, and right to be produced before magistrate within 24 hours. He should be produced within 24 hours to the court, excluding the journey times. Right to be produced before magistrate within 24 hours. And next, right to be released after 24 hours without the authority of a magistrate. He should be released after the 24 hours without the authority of magistrate. See, these rights are not available to the enemy alien, and also not available to a person arrested or detained under a prevention detention law. And next we'll see second part, detention in certain cases. These are the cases of preventive detention law. In this, right to be informed of the grounds. See this, the exception grounds not to be disclosed if that is against the public interest. If it is against the public interest, it cannot be disclosed. And right to make a representation against the detention order, and right to be released after 3 months unless report of advisory boards suggest otherwise. This detention in certain laws, protection of detention in certain laws are available to both citizens as well as aliens. This protection against the arrest is available to only citizens, not on enemy aliens. And next we have Article 23 to 24, right against exploitation. Article 23 says that the prohibition of traffic in human beings and forced labor. Article 23 says that prohibition of traffic in human beings and forced labor. See, it prohibits the traffics in human beings and beggar, forced labor, and other similar form of forced labor also. It's applicable to the citizens and non-citizens both, and it protects the individual against the state and private persons. Again, there are some exceptions. State can impose compulsory service for the in public purpose, military service, and social service. And next we have Article 24, prohibition of employment of the children in factories. See, the employment of children below 14 years, less than 14 years of the age, it is prohibited in any factory, the working in any factory or a mine or any other hazardous employment, and it is applicable to the all children regardless of the citizenship status. Again we have a exception here, no prohibition for harmless or innocent work. No prohibition on the harmless and innocent work. And next, article 25 to 28, right to freedom of religion. Article 25 says that the freedom of conscience and a free profession, practice and a propagation of the religion. The first one, conscience, means it is the inner freedom or a relation with the God. Next, right to profession, declaration of religious belief. And next, right to practice is worship, rituals, ceremonies, etc. And right to propagate, the transmission and dissemination of one's religion's belief. This article applicable to both citizens as well as non-citizens. And no right to forcibly convert any religion. Again we have exceptions here, public order, morality, health and other provisions relating to the fundamental rights, and state is permitted to regulate or restrict any economic or a financial or other secular activity associated with religious practice, and provide for social welfare and reform or thrown open Hindu religious institution of public character to all classes and sections of Hindus, etc. Hindus such as Sikh, Jain, Buddhist, we have all these exceptions in public order, morality, and state can either permit or restrict. Next we have article 26, freedom to manage religious affairs. This article says that the right to establish and maintain institution for religious and charitable purpose, and they have a right to manage its own affairs in a matter of religion, and they have a right to own and acquire movable and immovable property, and right to administer such property in accordance with the law. Again we have a restriction or exceptions here, public order, morality and health. Next we'll see article 27, freedom from the payment of taxes for the promotion of any religion. No person shall be compelled to pay any taxes for the promotion or a maintenance of any particular religion or a religious denomination. The taxes can be used for the promotion or a maintenance of all religions and not any particular religion. See, the tax can be used for the promotion or a maintenance of all religions and not any particular religion. Next we'll see article 28, freedom from attending religious instruction or worship in certain educational institutions. In this, the types of educational institutions, like institutions wholly maintained by the state. If it is maintained by the state, fully maintained by the state, the religious instructions are completely prohibited here. If the institutions administered by the state but established under any trust, then in such cases religious instructions are permitted. Next, the institutions recognized by the state, in that religious instructions are voluntary basis and the consent is required. And next, institutions receiving aid from the state. If the institutions are receiving the aid from the state, again the religious instructions are voluntary basis. See, if it is fully maintained by the state, religious affairs are prohibited. If it is the institutions are administered by the state but established under any trust, religious affairs are permitted. And institutes are recognized by the state. If institutions are recognized by the state, again voluntary base. In this institution, the religious instructions are voluntary basis. Again, institutions are receiving the aid from the state. If institutions are receiving the aid from the state, from state institution receiving the aid from state, again it is religions instructions are here voluntary basis. Make a note of it. Next we'll see cultural and educational rights, Article 29 to 30. Article 29 says that protection of language, script and cultural minorities. Article 29 says that they recognize the right of individual to preserve the culture, language, script, okay, and it prohibits the state from making any discrimination while granting the access to educational institutions. The Article 29 grants protection to both linguistic minorities, both and in religious. It protects the both linguistic minorities as well as religious minorities. The scope of this article is available to all sections including majority, and it is applicable to Indian citizens only. See, this Article 29 is applicable to only Indian citizens. Next we'll see Article 30, right to minorities to establish and administer the educational institutions. See, Article 30 grants the rights to minorities both religious or linguistic. They have a right to establish or administer the educational institution to their choice. They have a choice, and right to get adequate compensation if property acquired by the state. They have a right to get adequate compensation if property acquired by the state, and they have a state shall not discriminate. In this, state shall not discriminate while providing aid to the minority institutions. See, Article 30 confined only to minorities, religious or linguistic, unlike the Article 29 while extending to all sections. Article 29 provides to all sections, but 30 is only to minorities such as either religious or linguistic. Minorities only for religious or linguistics, not all sections. And minorities, the term has not been defined anywhere in the Constitution. See, the minority term has not defined anywhere in the Constitution. Next we'll see Article 32, right to constitutional remedies. See, the Dr. B.R. Ambedkar said that the Article 32 is the heart and the soul of the Constitution, and Supreme Court says that the basic structure of it is a basic feature of the Constitution, cannot be taken away by the way of constitutional amendment. We have a writs in this Article 32, habeas corpus, mandamus, prohibition, and certiorari, and quo warranto. Article 32 contains that the right to move Supreme Court for the enforcement of the fundamental rights, and the Supreme Court shall have the power to issue direction or orders, writs for the enforcement of the fundamental rights. And the right to move Supreme Court shall not be suspended except as otherwise provided by the Constitution. And the Parliament can empower any other court to issue direction or orders or writs. Supreme Court and High Court can issue various writs under the Article 32 and Article 226. Supreme Court and High Court can issue various writs under the Article 32 and the Article 226. Okay, now we'll discuss types of writs. First one, habeas corpus. That means to have the body of. See, the Supreme Court or High Court can cause any person who has been detained or imprisoned to be physically brought before the court. The court then examines the reason for his detention, and if there is no legal justification of his detention, he can be set free. Okay, if there is no legal justification of his detention, he can be set free. Here, It can be issued against both public authorities as well as private individuals. Next we'll see mandamus, that means weak command. The Supreme Court or High Court orders to a person or a corporate or a lower court, public authority or a state authority to perform their specific duty. It can be issued against a private individual or a body to enforce a contractual obligation, or against the president or governors, and against the Chief Justice of High Court acting a judicial capacity. And this mandamus, it is a command issued by a court to a public official asking. It is a command issued by the court to a public official asking him to perform his official duties that he has failed or refused to perform. And it cannot be issued against the private individual. Next we'll see prohibition to forbid. It is issued by a higher court to a lower court or a tribunal to prevent the latter from exceeding its jurisdiction or usurping jurisdiction that it doesn't possess. This prohibition issued by a higher court to a lower court or to a tribunal to prevent the latter from exceeding its jurisdiction. It can be issued only against the judicial or quasi-judicial authorities. It can be issued only against the judicial or quasi-judicial authorities. Next we'll see certiorari, to be certified or to be informed. It is not available against the legislature bodies and private individual bodies. It is issued by a higher court to a lower court or a tribunal either to transfer a case pending with the letter to itself or to squash the order of the letter in case. It is issued by the higher court to lower court, and it is not available against the legislative bodies and private individuals or bodies. Next we'll see quo warranto, by what the authority are warrant. It is issued by the court to inquiry into the legality of claim of person to a public offices. It is issued by the court to inquire into the legality of a claim of a person to public offences. Hence it prevents the legal assumption of a public offices by person. It cannot be issued by a cases of ministerial offices or a private offices. Study about fundamental duties. Okay, if you have not yet subscribed to my channel, please subscribe, like, share and comment. Okay, let us start. See, though the rights and duties of the citizens are correlative and inseparable, the original constitution contained only fundamental rights and not the fundamental duties. So, the original constitution did not mention the fundamental duties. Later, through the Swaran Singh Committee recommendation in 1976, by the Constitutional Amendment Act 42nd in 1976, fundamental duties were added to the Constitution. 10 fundamental duties were added initially in Part 4A, in Article 51A. And later in 2002, by the 86th Constitutional Amendment Act, one more fundamental right were added related to education. We'll see next. Okay. Next, list of fundamental duties. To abide by the Constitution and respect its ideals, institutions, national flag and national anthem. That means everyone should respect the ideals, institution, national flag, national anthem. Next one, to cherish and follow the noble ideals that inspired the national struggle for freedom. And this, we should also cherish and follow our noble ideals that who have struggled for our freedom. We should give respect to the freedom fighters. Next, we'll see to uphold and protect the sovereignty and unity and integrity of the India. We should uphold and protect the sovereignty, unity, and integrity of India. Next, fourth one, to defend the country and render the national service when called upon to do so. Whenever the emergency, whenever the country gets necessary, that time we should be ready to defend the country. Next one, to promote the harmony and the spirit of common brotherhood among all the people of India, transcending religious, linguistic, religion, or a sectional diversities, to renounce the practice of derogatory to dignity of the woman. It's telling that promote the harmony and the spirit of common brotherhood, should be common brotherhood, and renounce the practice which are derogatory to the dignity of the woman, such as sati, devdasi. Okay, next, to value and preserve the rich heritage of the country's composite culture. To value the preserve the rich heritage of the country's composite culture. We should preserve our heritage culture. And next one, to protect and improve the national environment, including the forest, lakes, rivers, wildlife, and to have a compassion for living creatures. Should have the compassion for the living creatures. We should protect and improve the natural environment, including forests, lakes, rivers, and should have a compassion for the living creatures. Next one, to develop scientific temper, humanism, and the spirit of inquiry and reform. Next one, to safeguard public property and to observe violence. Next one, to strive towards the excellence in all spheres of individual and collective activity, so that the national constantly rises to higher levels of endeavor and achievement. Next one, provide opportunity for the education to his child between the age 6 and 14 years. This fundamental duty later added to the constitution by the Constitutional Amendment Act 86th in 2002. Next we'll see features. First one, some of them are moral duties and while others are civic duties. For instance, cherishing the noble ideals of the freedom struggle is a moral precept, and respecting the constitutional, national flag, and national anthem is a civic duty. Okay, next one, confined to see the fundamental duties are confined to citizens only and do not extend to the foreigners. See, these fundamental duties are confined to only citizens, not it doesn't extend to the foreigners. And next, fundamental duties are non-justiciable. Like the directive principles, the fundamental duties are also non-justiciable. The Constitution doesn't provide for their direct enforcement by the courts, and there is not legal sanction against their violation. However, the Parliament is free to enforce them by suitable legislation. Next one, the fundamental duties refers to the such values which have been part of the Indian tradition. They refer to such values which have been a part of Indian tradition, mythology, religions, and a practice. In other words, they essentially contain just a codification of tasks integral to the Indian way of life. And in other words, it contains just a codification of tasks integral to the Indian way of life. That's all about features. Next, we'll see significance. See, the fundamental duties act as a reminder to the citizens. The fundamental duties serve as a reminder to the citizens that while enjoying their rights, and they should also be a conscious of duties they owe to their country and their society and to their fellow citizens. The fundamental duties are warning against the anti-national and anti-social activities like burning the national flag, destroying the public property, and etc. Next one, The fundamental duties, they serve as the sources of the inspiration for the citizens. This serve as the sources of inspiration for the citizen and promote the sense of discipline and a commitment among them. They create a feeling that the citizens are not mere spectators but active participants in the realization of the national goals. Next significance, the fundamental duties help the courts in examining the and determining the constitutional validity of a law. And next and the last one, they are enforceable by the law. Hence, the parliament can provide for the imposition of appropriate penalty or punishment for the failure to fulfill any of them. Okay, that's all about. I hope you all have understood this topic. If this video helps you in any way, please like, share, and comment. Okay, thank you.